So good afternoon, everyone, and welcome to our webinar on the changes to the arbitration landscape in Dubai. My name is Christina Holiday, and I'm the Marketing and BD Manager for Hamdan Al-Shamsi Legal. This webinar is delivered by Hamdan Al-Shamsi, Senior Partner and Founder, along with Robert Whitehead, Senior Associate, from Hamdan Al-Shamsi Lawyers and Legal Consultants. We also have some experts from the UK, James Collins and James Glacier, both partners at Candy, and Aidan Casey, QC, barrister at 3 Hare Court. The following presentation is for educational purposes only and will be recorded and may be published in various media without further notice. For all your questions, please share them on the webinar chat, and at the end, there will be a Q&A session where all your questions will be answered by our legal experts. Thank you for your attention. I will now hand over to Robert, my colleague. Thank you.
Yeah, thanks, Christina. So what I'd just like to do is just explain how we'd like to present this webinar. So there's going to be 6 areas which we'd like to discuss, which myself and my colleagues will go through. So I'm looking at the overview of the decree itself. So on the 14th of September 2021, Dubai Decree number 34 of 2021 concerning the Dubai International Arbitration Centre was issued, along with a new statute which is on the back of that decree. Now this decree and statute reforms the arbitration landscape in Dubai, and essentially it comes into immediate effect from the 20th of September 2021 in accordance with Article 10. Some of the key provisions which are really interesting as part of this decree and statute are the fact that the Emirates Maritime Arbitration Centre and the DIFC Arbitration Institution are to be abolished. And as of the date, all assets, employees, financial allocations, and lists of arbitrators, mediators, and experts of the abolished centres will then be transferred to DIAC Centre. So essentially, the DIAC Centre will replace the Emirates Maritime Arbitration Centre and the DIFC Arbitration Institution in all its rights and obligations. So what's also really important is the intended positive objectives of the Dubai International Arbitration Centre. So essentially it was put in place to establish Dubai as a leading global centre for alternative dispute resolution, to serve the Emirates financial and business community, but also to promote alternative dispute resolution mechanisms. So it's obviously a major step forward for Dubai, and we anticipate further changes, which I'd now like to pass over to my colleague, James at Candy, who will discuss arbitrations which are currently on foot, which have been administered by the DIFCLCA.
Well, thanks very much indeed, Rob, and a very good afternoon to you all. As Rob says, looking first at arbitrations currently on foot with a tribunal constituted, which had been administered by the DIFCLCA before the decree was issued. Article 6B of the decree provides in no uncertain terms that any tribunal formed under the rules of the DIFCLCA will continue to consider arbitration cases before them without interruption. However, further practical guidance subsequent to the decree was provided by way of a DIFC press release in October 2021, which advised as follows. Firstly, any arbitration subject to the DIFC-LCIA arbitration rules which commenced before the 20th of September 2021 would continue with the LCIA as the administering body, effectively on a secondment basis from the DIAC. Whereas any arbitration agreements which are subject to the DIFC-LCIA arbitration rules and where an arbitration had not commenced before the 20th of September 2021 would be subject to administration by the DIAC as opposed to the LCIA. So what are the practical implications of this approach? Well, As is often the case with arbitration, we have to deal with anecdotal evidence to extract trends, but that evidence suggests that parties and their legal representatives have experienced some delays to their processes, particularly when it comes to communications with the LCIA and DIFCLCA. This will no doubt have been a source of frustration to those parties and their lawyers, but we'd suggest that this is a predictable side effect of the transitional period necessitated by the decree. Staff at the LCIA and DIAC have quickly had to grapple with the administration of a substantial number of new cases. But one advantage of the approach concerning pre-20 September arbitrations that I think should not be overlooked is the fact that it maintains the approach as best it can the party's original election to have their disputes administered by the DIFC-LCIA. Arbitration is, as we all know, a creature of consent. So any efforts, I think, to respect features of that consent between the parties are to be viewed as a positive, I think. But I'll now hand over to my partner and colleague at Candy, James Collins, who will now consider potential strategic steps to be taken by arbitral parties.
Many thanks indeed, James, and good afternoon to everybody. I apologise in advance that some of the points that I'm making here are somewhat doomsday in nature, because if the parties are content with the decree and its implications, then extant arbitrations can just continue in earnest, of course, and the parties will substantively engage, as was always the intention. I just set out here some strategic points that parties should be aware of when they're thinking about what position they do indeed want to adopt in those proceedings. So the first bullet notes, don't blow hot and cold. What's meant by that? Well, parties do need to be aware of continuing to substantively engage with the next stages in an arbitration following the enactment of the decree. Because if the parties do proceed on the basis that it's very much business as usual, then it will be very difficult for them to try and renege on that position at a later stage. For example, if they try and say, we're now going to try and resist enforcement of an award that we don't like, notwithstanding that we have engaged throughout the arbitration process, and notwithstanding that we were fully aware of the impact of the decree at an earlier stage. So what does this mean in practice? It does mean that parties to extant proceedings need to immediately start thinking about whether they're comfortable with the change in arbitral institution enacted by the decree. If they do take a substantive step in the proceedings, let's say you're about to file your defence or file a Redfern schedule or a response to a Redfern schedule, then if you do that, then you'll subsequently find difficulty to try and row back from that position if it comes to enforcement and you're not happy with the outcome. From the party's perspective, obviously, there's the claimant's position. So the claimant's going to be considering whether it wishes to continue to prosecute its claims in the existing arbitral forum. If I can make a slightly opportunistic observation, if the claimant does see that the writing may, for example, be on the wall for the substantive merits of its claims before an existing tribunal, it doesn't like the way the wind's blowing, let's say, it could conceivably throw up its hands and say, well, this isn't the agreed arbitral procedure that we thought we'd signed up to originally. It's been removed from underneath us. So all bets are off. We're going to go and we're effectively discontinuing or withdrawing from these proceedings, and we're going to, let's say, start a court action somewhere locally. That conceivably is an option, but we would urge caution there because, as we say, in reality, it's unlikely to be a meritorious stance. And also, and I'll come to this a little bit later, if there is a jurisdictional objection raised, then it's pretty standalone. This is a standalone development that's not relevant to the merits of any arbitral case that's on foot. So it should be able to be resolved as an objection within the framework of the existing arbitration and by the existing tribunal. From the respondent's perspective, if they're happy to engage, great. However, if they're worried about the outcome again, and they want to try and keep their powder dry when it comes to enforcement, they may wish to down tools on an ongoing basis in the arbitration. One alternative might be that you reserve your position on the tribunal's jurisdiction. You may say, our primary position is that this tribunal no longer has jurisdiction because of these recent developments. And if we do get into the merits of the dispute and start substantively engaging, then we do so without prejudice to that contention. What I would say there is any such argument to that effect should be capable of being dealt with on a bifurcated basis or on a freestanding basis by the existing tribunal. So that tribunal should be able to resolve that issue definitively before it gets to enforcement. And so the final point is possible enforcement challenges down the track. Again, there's a slight degree of opportunism here, because if a party in isolation, looking at the way its dispute has been going before its existing tribunal, is pessimistic about its chances on prospects, for example, it may, as I say, somewhat opportunistically seek to disengage from those proceedings and hold back pending any attempts to resist enforcement. But as touched on above, and as will be developed further by Aidan and other colleagues in this talk, our sense is that that would be an uphill struggle to try and convince a local court when it comes to enforcement to uphold such challenges. On the subject of challenges, I'll now hand over to Hamdan, who will discuss potential challenges to enforcement.
Thank you, James, and thank you to everyone that has joined us. So I think James has brought up a myriad of potential challenges that can be brought up by parties, and which are certainly true. Parties will resist enforcement if the award is unfavorable. And in that respect, the most likely challenge is, of course, the agreement to arbitrate and the centers have been abolished. Parties will certainly seek to say that the center is no longer there and has been abolished. And as such, they will resist they would bring that up as a challenge to any enforcement, let alone ratification. From my experience, generally parties do focus on procedural elements in terms of and challenges. And when it comes to enforcement, that is when, again, they bring up arguments of the centers being abolished, including as well the procedural elements that haven't been followed. Which leads me to say really that when it comes to the arguments of the centers being abolished, they might find those kind of challenges weak in the UAE, only because it is a decree that has abolished the centers and have formed a new center. Well, they've merged all the centers into the DIAC as a new center. Therefore, that referral is pretty clear in the court's eyes, making any challenge really difficult in the UAE. In terms of procedural, I think that is a point that is important. If the parties have agreed LCIA procedures should be followed in respect of their arbitration, then any party can, of course, challenge the arbitration if it did not follow those procedures. And there might be a confusion with the arbitrators themselves or the parties which rules they should follow, whether it should be DIAC or LCIA. During the course of any arbitration or any arbitration that is current, they should follow the rules that have already been set by the parties and of the arbitration centers. And strictly speaking, they should follow those rules and not necessarily apply the rules of DIAC. However, it comes, there can be some confusion with the fact that the rules pertaining to stopping arbitrations or for their time limits for that purpose, they are rules that are different than one another between DIAC and LCIA, which may cause potential challenges to any enforcement, and before enforcement, of course, ratification as well. I will go to and move on to the potential challenges to enforcement. There are, the first scenario is that a party is waiting for an award, and upon delivery of the award, losing party seeks to resist enforcement. And in such a case, what would happen generally is that the party will resist such enforcement at the courts. And in the local courts, in the Dubai courts, how the enforcement procedure happens is that a party will submit to the appeal courts an application to enforce the award or ratify before then, of course, the award, and the respondent will have a chance to appeal such order awarded to ratify the arbitration award. And in that appeal, he may provide his challenges to such an award. And another scenario where there's a new dispute and one party seeks to issue proceedings in the court or otherwise to challenge the jurisdiction of the arbitrators. In such a case, the challenge would be, depends really whether it was after the 21st of September or before. As we all know, the decree takes effect on the 21st of September, and one must be very careful about the exact date of when his arbitration started, which under the laws of the United Arab Emirates is the first date that the arbitration panel conducts trial or meets with the parties. And as such, the rules that should be followed would be that of the UAE or DIAC post 21st of September, if they met then, and before 21st of September, it would follow the LCIA or the UAE Maritime Arbitration Center. And with that, I will pass the microphone to my colleague Aidan to speak about challenges outside of the United Arab Emirates.
Thank you, Amben, and good afternoon, everyone. It's a pleasure to be speaking to you. So I'm going to consider possible enforcement and jurisdiction challenges that might be attempted following the decree, but how they might fare in jurisdictions other than the UAE. And as Hamdan says, we can envisage two main categories of case in which arguments might arise where you're dealing with a legacy arbitration agreement that specifies DIFC, LCIA arbitration. And generally speaking, I'll speak about DIFC, LCIA to capture both that and EMEC. So first you might have a challenge to enforcement of an award and delivered after the decree. And secondly, an attempt to dispute or challenge the jurisdiction of a tribunal formed after the decree. Now, the second scenario is probably more important in practice, and it's certainly that type of case, which has given rise to most of the reported cases you'll find referred to in the textbooks. And just before looking at some of the case law, we should look briefly at some key relevant provisions of the New York Convention, which hopefully you have up on your screens. Firstly, Article 5.1d in the context of enforcement, as many of you will be familiar with, recognition and enforcement of the award may be refused upon proof that the composition of the arbitral authority was not in accordance with the agreement of the parties. So you can see that the losing party on our first scenario might try to argue that the composition of the arbitral authority was not in accordance with the agreement of the parties due to the change in institution. And as to the second scenario, it'll be Article 2.3 most likely, which is relied upon. Courts of a contracting state, when seized of an action, may decline to refer the parties to arbitration if it finds that the arbitration agreement is, in particular, inoperative or incapable of being performed. And again, you can see that a party on our facts might say, well, our arbitration agreement provides for DIFC, LCIA arbitration. That institution has been abolished. Hence, the agreement's inoperative or incapable of being performed. And that is an argument that one sees has been repeatedly attempted in cases dealing with abolition of institutions. So now, in terms of guidance that can be derived from the jurisprudence in this area concerning non-UAE jurisdictions, firstly, you can find a lot of cases and academic commentary on what have come to be called pathological arbitration agreements, meaning essentially arbitration agreements which are in some way defective. And now one well-recognized species of potential pathology is the selection in the arbitration agreement of an arbitral institution which doesn't exist or is inadequately defined. And there are quite a number of examples of cases where, through errors of drafting or inexpert drafting, arbitration clauses use names of institutions which do not and have never existed. and sometimes in the cases you'll see quite wacky formulations in what were presumably contracts drafted by non-lawyers, but where the end result is a simple nonsensical naming of a non-existent institution. Now, in these sorts of cases in general, there's a strong tendency for national courts to hold the parties to their agreement to arbitrate. And the cases tend to proceed on the basis that the agreement to arbitrate is paramount, and that the purported selection of a non-existent arbitral institution is nonsensical, completely ineffective, and can be ignored, such that it doesn't infect the primary agreement to arbitrate. And we might derive some guidance from that in terms of the cases that we're anticipating. But there's a recognized subspecies of potential pathology, which occurs when there is a selection in the arbitration clause of an arbitral institution which did once exist, but has ceased to exist. And that, of course, is the scenario we're looking at today. And you can see that somewhat different arguments can apply here, as there's no doubt about what the parties intended at the time of contracting. And indeed, at the time of contracting, it was no doubt perfectly effective. So it's not a case of nonsensical or impossible provision in the clause. Now, there are some, but far fewer examples of this type of possible pathology in the reported cases. And in summary, there is in these cases too, a strong but not universal tendency to uphold arbitration agreements and to hold the parties to their agreement to arbitrate when the selected institution has ceased to exist. A wide variety of mechanisms are used by the courts to do this, and it won't be possible in the time we have today to do more than somewhat scratch the surface. But we can try to pick out a few examples from the comparative jurisprudence to give you a flavor of the reactions of national courts to these types of cases. So the first case I would refer to is a decision of the Paris Court of Appeal in 2012, which I think if we can move to the next slide, we'll see the name of that case. So this was the SAS ADB case. In this case, the arbitration agreement had selected an institution, the German Arbitration Committee, that no longer existed by the time of the dispute. It had been replaced by another institution, the German Arbitration Institute. And the GAI was the assignee or successor of the GAC. And the court held that the arbitration agreement was valid and enforceable, and that as the assignee, the GAI should administer the arbitration. And this case, you may think, reflects a principle that's been recognized in some of the US cases, that in the ordinary run of things, institutions may evolve or merge and so on, and the parties should, where the drafting of the arbitration agreement permits this, be taken to have recognized that fact when entering their arbitration agreement. And this is interesting because under the decree, the DIAC is expressly designated as the assignee or successor of the DIFCLCA, has been previously described. There are also a body of interesting case law arising out of the dissolution of the former Eastern Bloc. And broadly speaking, we can identify two strands of cases. Firstly, cases where there's an identifiable successor and where there are no special features unique to the dissolved institution as compared to the successor institution. And in these cases, again, the courts tend to conclude the arbitration is enforceable. So there is a decision of the Austrian Supreme Court, for example, in 1994 concerning a dissolved USSR arbitration institution. And the Austrian Supreme Court considered that there was a successor, an identifiable successor, and held that the arbitration agreement was enforceable with the successor of the selected institution. But then there's a body of cases where the dissolved institution had some important distinctive feature and not shared by the successor, or where there's no identifiable successor, and they've led to a refusal to enforce. So there are some Belgian and German decisions that fall into that category, in particular relating to the dissolved East German Arbitration Court under the old GDR. And the Brussels Commercial Court and the German Supreme Court have found in a number of cases that arbitration agreements on that scenario were unenforceable. Now, in those cases, they made reference in particular to the fact that under the rules of that GDR institution, there were special features, for example, relating to the constitution of the tribunal, which couldn't be read across to the successor institution, the Berlin Arbitration Court. And so they focused on that in particular in concluding that the parties shouldn't be held to the arbitration agreement. Well, now, in broad terms, where does this leave us, where you have legacy arbitration agreements specifying DIFCLCA? I think the answer is we can expect challenges to be attempted, as Hamdan has said. There's no limit to the ingenuity of lawyers, especially when large sums are at stake. But as a starting point, I think it's fair to say that courts and tribunals in all of the major jurisdictions are likely to be skeptical of these challenges. And this is so particularly given four factors in the present scenario. Firstly, the decree in Article 6A expressly deems as valid all legacy arbitration agreements. And that'll be particularly relevant where DIFC law is the governing law of the arbitration agreement. Secondly, the DIAC is expressly designated by the decree as the successor or assignee. Thirdly, in the transitional period, the DIAC will operate using the DIFCLCA rules. So there's no question of an argument during that period of some important distinction in the rules. And finally, I think we can be confident, given the identity and caliber of the people involved, that the new DIAC rules, when promulgated, will be modern and effectively best in class. So when you look at some of the features which have led in the past courts to conclude arbitrations were unenforceable, we can see that those features are not or are highly unlikely to be present in the context of the changes brought about by the decree. So with that somewhat whistle-stop tour of what's quite a deep area of law, I'll pass you back to Rob, who's going to deal with the next topic on the agenda.
Thanks, Aidan. So what we'd like to just discuss now and consider are arbitration agreements which provide for DIFCLCA arbitration, but with no arbitration which are on foot. So essentially, this is addressed in Article 4B of the statute, in that DIAC will now become the administering institution unless it's otherwise agreed between the parties. So unless the parties agree between themselves in writing or verbally, and it's confirmed with the tribunal, then that will be the situation. It'll be the DIAC Arbitration Centre. So essentially, in these cases, which arbitration law applies, it will be the DIFC arbitration law which will apply. The relevance of this is very important for Dubai, and I think that's one of the reasons, again, bringing back my earlier discussion on the importance of this change. So it should promote Dubai as a global seat of arbitration. And this is also supported by the DIFC courts, which are firm often in the courts, and we've got a number of cases. So this is supported by the DIFC courts' growing expertise in arbitration, and also through English language proceedings. So essentially, it will mean that international organizations and companies will feel more comfortable and more at home. The significance of this is that the new Dubai International Arbitration Centre will have its headquarters in mainland Dubai. It will also have a branch in DIFC, and it will consist of a new board of directors, a court of arbitration, and an administrative body to have overall supervision and management of the centre. So with that, I'd just like to pass over to my colleague James, who will discuss the next topic.
Thanks, Rob. So should parties look to amend their contracts now, immediately? The first point to note is it's never a bad idea for commercial parties to look back at their existing commercial contracts and commercial relationships, check the arbitration agreements to which they've signed up previously, and work out the sets of rules which are going to govern their relationships. Here we're talking typically about contracts entered into prior to 20 September 2021 when the decree is enacted. So you're scrutinising whether the DIFCLCA rules is what you provided for in your arbitration agreement for those pre-existing arrangements. If you did, our practical advice is that you may want to hold fire for the time being on seeking to amend clauses. I say that with the caveat that if the parties are very much happy and engaged with each other and there's no sense of conflict or anything, there's nothing of course, to stop the parties providing in terms now for the DIAC as a result of the decree, and that will just nip in the bud any conceivable suggestion that arguments could be raised that a clause is somehow inoperative at a later date, factoring in the fact that the DIFCLCA rules are stated as the arbitral institution. The reason why parties should feel relatively comfortable about preserving the status quo for the time being is because the range of sensible transitional arrangements that Robert and Aidan were alluding to earlier. So the decree makes very clear that the DIFCLCA rules will continue to be the rules which the DIAC as administering institution will refer in the meantime. And the DIFC court, which of course is a very experienced expert supervisory court, will have supervisory jurisdiction over those disputes. So the parties have a very sensible and pragmatic interim regime in place to govern any disputes that may arise in the near future. The second point on the slide there is that the new iteration of the DIAC rules is on the way. As we understand it, the new iteration is expected within 6 months of the enactment of the decree. So very much a case of watch this space, because that will be during the course of next month at the latest. Once those rules come out, the parties should carefully check those rules once published to ensure that they serve the necessary purposes the parties were envisaging. But as a number of colleagues have touched on in this call, in this talk, given the key objectives of the new DIAC, notably to establish Dubai as a leading global centre for alternative dispute resolution, we're certainly anticipating that these are going to be a market-leading set of institutional rules. We expect that they'll have all of the bells and whistles that we've seen on more recent institutional rules that have been published, such as the ability to appoint emergency arbitrators for urgent proceedings, to consolidate proceedings, to seek to join third parties into arbitration agreements, and so on. So with that, I'll hand back to Robert, if I may, to discuss the next topic.
Yeah, thanks, James. So the last question just on this area, this section, which is quite an interesting question, is what happens if parties include provisions for DIFC-LCA arbitration in their arbitration agreements after the decree was enacted? This wasn't particularly clear, and we've had to look at various sources for this, particularly Article 6A and Article 9 of the statute, and also the DIFC and LCIA press releases. Now, what we've deduced from that is that all new arbitrations which are commenced after 20th of September 2021, whether under agreements providing for DIFC, LCIA or EMAC arbitrations concluded before or after the decree came into force, these will be administered by a DIAC in accordance with the DIAC rules, again, unless the parties agree otherwise. So that's clarified the situation on that, and there's various DIFC press releases and LCIA statements which are available, and we can provide to listeners if they like, which confirm this. So with that, I'd like to hand over to my colleague Hamdan, who will consider the future of arbitration and arbitration agreements that have a Dubai nexus.
Thanks, Robert. So as we have noticed in the last 20 years, I think Dubai has focused on making Dubai an arbitration hub. It's a city that has quite competent lawyers. It's a city that is favorable, as a city that sits really in the middle between Europe and Asia, and as well Africa. And it's quite desirable for cross-border transactions or parties to really arbitrate in Dubai. Now, one of the interesting things as well we've noticed is they've considered arbitration funding. So you noticed in Article 8.4, the board of directors are to establish rules in respect of arbitration funders. And I think litigation funders in the last 15 years have grown a lot. I've noticed them more and more in my work. They are, for large cases, they've become an integral part or a very important part for a lot of litigators. This should ensure that Dubai is a favorable jurisdiction for arbitration by offering those different funding options and recognizing litigation funders. Dubai is to remain as a leading arbitration hub for disputes. It has put in the effort in the last 10 years. In the region, it does serve as the arbitration hub. And it's likely as well that DIAC will soon issue its new arbitration rules to replace the 2007 DIAC rules. And this will likely be required to strengthen Dubai as a global center for dispute resolution, and in order to apply international best practice. With that, I'll hand over to my colleague, James.
Thanks very much, Hamdan. The next point on this slide hints at a prediction being given here, and I know listeners will sometimes find it frustrating listening to predictions given by lawyers, couched as they so often are in caveats. So I'll do my very best to steer clear of that sort of approach. But I'd like to actually sort of take issue, first of all, with the way that the question is put on the slide. In fact, the suggestion that it is the decree itself that has led to administrative complications. As discussed, the wording of the decree is in fact quite clear, and we've noted that in this webinar, which institution is to administer an arbitration previously subject to the DIFCLCA rules, for example, depending on the date on which that arbitration was commenced. Instead, it seems that the administrative complications have in fact been caused by, it would seem, the institutions having to, quite short notice, take on a substantially number of new cases, and in quite abrupt circumstances. And so predicting when administrative complications caused by this decree will subside is actually quite difficult, because much depends on the inner workings of those institutions. But given, I think, in our view, that these complications can be characterized more as teething problems, as opposed to, say, kind of apparent faults with the decree itself, we see related delays subsiding within a matter of months as opposed to years. But as a further note on this point, undoubtedly an important step will be the release of the new DIAC rules, and the decree itself envisages those being released within 6 months of the decree, so towards the back end of the first quarter of this year. The new rules will, of course, provide welcome clarity for parties as to what it is they are signing up to when they refer to the DIAC rules in their arbitration agreements. And as has been noted by both James and Aidan, we expect these new rules to be to have some of the most favoured provisions of other world-class institutions, such as the provision of clarity and guidance on consolidation, and to allow, for example, arbitrators to make summary judgments. But I think enough on predictions. I think it leaves me to hand back to Rob on the certainties of the conclusions and the takeaways that one can take from this webinar. Thanks, Rob.
Thanks, James. Yeah, I think so. We just sort of would like to sum up some of the key points in this webinar. I think one of the main points, and it sort of goes without saying, but it needs to be said, is that any new agreements should avoid providing for arbitration under DIFCLCA rules or EMAC rules. That's really the key takeaway from this. From both a sort of a lawyer's and a sort of a layman's point of view, from a contractual point of view, must avoid that to avoid these complications. And then obviously the first point being that pre-existing arbitration cases should continue in earnest under the auspices of existing tribunals, which have previously been appointed to administer those cases. So I'd just like to hand over to Hamdan now.
Yeah, we spoke about the challenges to enforcement in different jurisdictions, really. But we feel that those challenges will be difficult. The law is a decree, it's a decree that has been issued, and as such, there is certainly a referral of any LCIA dispute or arbitration to DIAC. Therefore, we find that most likely those challenges will be difficult to bring up. James, anything from your side?
No, I think we'd endorse that, Hamdan. I mean, perhaps I should call him Dr. Aidan Casey, with his lesson in pathology earlier, pointed out a number of the arguments that can be made with respect to pathological arbitration clauses. But looking at what the degree provides, I do anticipate that any such attempted challenges will fall on deaf ears. And if you are a local council or a client who wants to consider your options and next steps with your commercial contracts, you're both looking backwards towards the existing relationships to see how this decree affects them. And as Rob just noted, being very careful to avoid reference to the now abolished DIFCLCA rules when drafting your arbitration agreements. We've heard anecdotal tales of them often being called midnight clauses, because they can be the very final clause of a contract that's negotiated and put in at the 11th hour. But they are extremely important clauses. I would say that as a disputes lawyer, but they can have extremely significant ramifications. So it is very important as a contracting counterparty that you get those arbitration agreements extremely watertight and referable to the current arbitration landscape in Dubai, which is set out in the decree.
Well, I'll step in there. I've been called many things, but rarely called a doctor. But and hopefully the clauses we're talking about won't need very much by way of radical medical attention. I think the takeaway is that the structure provided by the decree is going to be very unfriendly to meritorious attempts at any challenge, whether to enforcement or jurisdiction. But that said, no doubt, as with the medical world, prevention is better than cure. And so, as Robert says, if anyone's engaged in drafting in the near future, we should certainly be watching out for inattentive keeping on of bits of boilerplates that refer back to the old institution. And if you're in a scenario where everyone is friendly at the moment and the contract's functioning perfectly well, there will come a time, either now or when the new DIAC rules are to hand, when it may well be sensible to do a little bit of keep fit rather than going to the doctor, and to bring those bits of the contracts into shape to follow the new regime. But at the moment, I think that's more sort of wise counsel rather than something that we see as being dramatically necessary in terms of salvaging clauses and so on. So I think I'll hand over to James Glacier to round up on the next point.
Yes, thanks, Aidan. And I think a final takeaway from this is that, look, with the initiation, with the release of the new DIAC rules, which I say everyone in this panel expects to be state of the art, I think DIAC can now, it really has new life has been kind of breathed into the DIAC, I think, and will be brought up to date with other leading international institutions. So parties in the future, when considering arbitration agreements for their future contracts, I think that they can rest assured that the inclusion of a DIAC arbitration clause, they'll be getting what is likely to be a state-of-the-art institution, and with up-to-date rules that contain some of the provisions that have been most favoured by parties around the globe.
Thanks, James. I think that brings us now onto the questions and answers. Christina, I don't know if you want to...
Yes, I think a lot of the people have missed the beginning. So we did say that if you guys have please any questions, if you could write it in the chat box so we can read out loud. Or if the question is too long, maybe raise your hands and then we can allow you to talk. Is there anybody who have any questions to the subject?
think we must have done a good job, guys.
It looks like the panel can breathe a collective sigh of relief.
Or you might need to give them time to write their questions.
Yeah, that's more.
I will give, I think, a minute or two.
Yeah.
Hi, Zaid. I think you raised your hand. Please go ahead if you have a question.
Yes, hi, good afternoon. My name is Zaid Wani and I'm a principal associate with Mahmood Hussain Law Firm. It was a pleasure to be part of this seminar. It was very insightful. I have a follow-up question. Perhaps I apologize if I may have missed out if this had been discussed, but I just wanted to get clarity on a hypothetical scenario. Obviously, it's not something that can be envisaged at this stage. But let's say that I intend to file a DIFCLCA arbitration, or there's a parties agreement on DIFCLCA arbitration, and bearing in mind the decree and the abolishment of DIFCLCA, and also noting that DIAC will take over, and that transition would obviously take some time. But what should a party do in a situation where there is a risk of a time bar, and they want to initiate arbitration? Whilst I understand that, the panel encourages the parties to revisit their agreement on the dispute resolution and perhaps revise the dispute resolution clause. But what if there is a time bar and one of the parties to a dispute wishes to at least initiate the arbitration to satisfy the time bar requirement? What would the panel advise in such a scenario? Would it advise to file it with the current landscape of DIFCLCI, or should we refer it to DIAC?
So if I could just ask a clarifying question. When you said time bar, so I mean, there's not necessarily a time bar for filing. It's just that if you do file right now, for example, a case under LCIA, you'll just need to proceed and submit your request to DIAC because LCIA has been abolished. By time bar, what did you mean by that? Is that what you meant?
Yes. I'll clarify. Let's say now, for example, in construction disputes, you have a time limit of 10 years to file a substantive claim, right? So let's say the parties have exhausted almost the entirety of that period, and just before the expiry of that 10-year time bar to file a substantive case while there is an arbitration clause, would then filing it before the DIFCLCIA be fruitful, or would it automatically be referred to DIAC, or should it automatically be submitted to DIAC?
Yeah, so anything in relation to limitation, so arguments of limitation, everything, if they have an arbitration clause, and it is an arbitrable matter. So, you should, in any event, proceed with arbitration, and most likely the respondent will challenge it on the basis of limitation that you did not claim within the 10 years that you should have under the UAE law. I don't know if any of my other colleagues has anything to add, but I hope that answered your question.
I would only add that under the decree, and sorry, I'm just pulling up the, I can give you the correct reference. Under Article 8C of the decree, for the time being, if you're dealing with a legacy DIFC LCIA contract, then the DIAC is to apply the previous rules of the DIFCLCA. So as Hamdan has said, the old institution has been abolished. So in terms of the institution with which you must file your originating process, your request for arbitration, that will be the DIAC, but you should prepare it in accordance with the rules, the old rules of the DIFCLCA, which for the time being are the rules under which the DIAC is going to operate. That would certainly be my analysis.
Yes, exactly, Aidan. So it's basically business as usual. You would refer to Article X of the DIFCLCA rules. It's simply you're submitting your request for arbitration to a different administering institution, namely the DIAC.
But then there's also an issue with that, because unlike many other institutes, DIAC does not administer arbitrations under different rules. If you're under DIAC rules apply. So would that be a hindrance in the enforceability or the veracity of the entire arbitral proceedings if we were to file before DIAC but under the DIFCLCA rules? I hope my question.
I mean, my analysis, Zayed, is that there are, because there are specific provisions in the decree. Decree 34 for this very scenario, where you have an arbitration agreement which refers to the DIFCLCA. The decree provides for that, look, any arbitrations initiated after the 20th of September 2021 will be administered by the DIAC under the decree, but still subject to the DIFCLCA rules, which, you know, as I say, are now old because that institution has been abolished. But the rules can be, as we interpret the decree, the rules can be viewed as separable from the institution itself. So the rules subsist for these purposes, even if the institution that actually spawned the rules has now been abolished. So I think, given the specific provision in the decree for this very scenario, I don't think there's any kind of cause for concern when it comes to enforceability down the line if you followed precisely what the decree says.
Yeah. So in that respect, any rules of LCI will continue, unless of course they contradict the rules of DIAC put forward. But I highly doubt that they would. But in any event, that you should follow the rules of LCIA. However, as much as they don't contradict with the DIAC rules, which are there of 2007, and the new ones which will be issued soon. I hope that answers that question.
It does. Thanks. That's very helpful.
We do have a question. Sorry. Do you want to read it out, Christina?
Just unmute myself, sorry. So thank you all. Is it likely that the shift to DIAC will provide third-party founders in cases where proceedings are already on foot with a potential avenue to withdraw from a particular case?
So just a clarifying questions to the anonymous person asked this question. Do you mean that is it a reason for a litigation funder to withdraw for funding a case because the risks of the case have changed materially? I mean, this will really depend. I mean, litigation funders generally do have a clause out, a clause to protect them, that if the opinion changes of the counsel materially, they may stop funding the case, or they might agree with the parties stop funding. Sometimes those clauses can be obviously agreed between parties, but they do have a termination, a clause to terminate if the risks of the case are materially different. And I think that's perhaps the question you're asking. And really, it really depends on the council's opinion or the legal opinion of the council, whether this decree necessarily presents a big risk to the case or not. From what we've provided, we don't believe that it should be. Most jurisdictions will accept a center referring to another, or being abolished and then being referred to another center. I'd like to ask my colleagues if they have any thing to say as well. There's respect.
Yeah, I think that's absolutely right, Hamdan. Obviously, all litigation funding contracts have got those clauses in there. That's just to protect themselves and obviously sort of both parties, but mainly themselves. So yeah, I think that's absolutely correct. And obviously, the only good thing, as Hamdan pointed out in the talk today, is that there's much more of a shift now under the statute towards allowing arbitration funders. So under Article 8.4 of the statute, it's sort of promoting that aspect. So yeah, not much more to say other than what Hamdan said there. Yeah.
Aidan, do you have
I would only add that I agree that on the face of it, it's hard to see how the changes brought about by the decree might engage one of those standard form provisions in funding agreements, which provide for the funding to be terminated if the risk profile of the case changes, or if lawyers or counsel advise that the risks have materially changed. Because on the face of it, given what we know and the structure of the decree, when it comes to actually handling the substantive merits of the proceedings, really nothing should change. Now, there may be scope, I suppose, for a funder who wants to back out to try and take some technical point. I mean, the funding agreement may define the proceedings, for example, as DIFCLCA arbitration number X. And so a funder who's so minded, I suppose, might try and fix upon that sort of argument. That would be very case specific, and you'd have to see the particular contract in question to really form a view. But I think on the face of it, that would look pretty unmeritorious. And you would have thought that given the modern approach to construction of contracts, it would be said, well, looking at what the decree does, and the parties to the funding agreement must be taken to have known that relevant Dubai and DIFC laws might change. Can they be taken to have intended that the contract would somehow be frustrated or brought to an end in this type of event? Difficult, I think, but again, you can't rule out the possibility that opportunistically a funder who wants to back out for some reason might try and take the point. But on the face of it, I would have thought it should be business as usual.
One thing that's interesting is the seat of arbitration, and because DIAC has now, the LCI has been abolished and the Maritime Center has been abolished, and DIAC now is on mainland and has a branch in the DIFC. I think it's become important for parties to agree the seat of arbitration, because really the seat of arbitration will mean which courts and which laws, unless in contract agreed, would apply to the arbitration process, and which courts really would handle any ratification or any challenges to the arbitration. And I think parties should really consider this in their contract. Now that LCIA and DIAC is one, the seat of arbitration becomes ever so important for parties to know which courts will handle any challenges over the process, the arbitration process. I think if there's no more questions, or if there is, be happy to receive them.
I think if there is no more questions from the audience, then maybe later on, if anybody has any questions, if we can just go to the next slide, all the contact details are there. So please, you get in touch with us. And I would like to thank you for everybody today for attending the webinar, and hope you find it very useful. And yes, thank you so much.
Thank you, everyone.
Thanks, everyone.
Thank you to the panel.
Thanks,
Thank you.
everyone.
Thank you, everyone.